Hi everyone, welcome back to Hands-Free Studying for the MBE with Brainscape. Today's video is about criminal procedure. So get ready and let's get started with our first set of cards covering arrests, searches, and seizures. Question 1. The Fourth Amendment has two major parts. It protects the right of the people to be secure from blank and blank, and it states that warrants must be supported by blank. The Fourth Amendment first protects people to be secure from unreasonable searches and seizures in their home by the government. And it states that warrants must be supported by probable cause. Question 2. What are 4 key questions that you should ask when approaching a Fourth Amendment question? First, was there a search or seizure? And if so, was the search or seizure conducted by a government actor? 2. Was there probable cause? 3. Was there a valid warrant? And if so, was the warrant defective or did the police act in bad faith? And 4. Was there an exception to the warrant requirement? Question 3. When will actions by a private individual trigger the Fourth Amendment? If the individual acted at the direction of a government agent or pursuant to an official policy. Question 4. What constitutes a seizure under the Fourth Amendment? A seizure under the Fourth Amendment is when an officer, by show of physical force or authority, intentionally restrains the liberty of a citizen so that they are not free to leave. Remember, this is a subjective standard. And in this context, a seizure is also called an arrest. Question 5. What factors help determine if a seizure has occurred? The basic rule is that if a reasonable person in the defendant's position would have believed that he was not free to leave, then it's considered a seizure. Some factors courts look at are whether there was a threatening presence of several officers, whether there was any display of weapons or physical touching of the person, and any indication that compliance with a request was in order. Question 6. What is required for a valid arrest? First, probable cause, and 2, a warrant, if the suspect is in their own home or another's home, absent consent or exigent circumstances. Question 7. When is an arrest warrant not required? An arrest warrant is not required if the arrest is in a public place, if the arrest is for a misdemeanor punishable by a fine and the police witness the misdemeanor. It's also not required if there are exigent circumstances or if the police had consent to enter the defendant's home or a third party's home. Question 8. Does an illegal arrest prevent the government from prosecuting the defendant? No. As long as the police have probable cause, they may prosecute and detain the defendant even if the arrest was illegal. Note, however, that any evidence seized during an illegal arrest may be suppressed at trial. Question 9. When can the police stop an automobile? Unless the stop is at a checkpoint, the police can only stop an automobile if they have reasonable suspicion of illegal activity. Question 10. When can a private citizen make an arrest? If 1. A felony has been committed, and 2. The citizen has a reasonable belief that the person being arrested committed the crime. Note, citizen's arrest can also be used as a defense if the citizen used reasonable force to detain until the police arrived. These upcoming criminal procedure questions cover confessions and self-incrimination. Okay, let's get started. Question 1. What is protected by the Fifth Amendment? The Fifth Amendment protects against self-incrimination. Question 2. The Fifth Amendment privilege against self-incrimination only applies to what type of statements? Compelled testimonial statements. Question 3. Under the Fifth Amendment, what is considered a compelled statement? A compelled statement is one that is elicited, coerced, or otherwise induced by a government actor, for example, through interrogations, polygraphs, or other things obtained pursuant to a subpoena. Question 4. Under the Fifth Amendment, what is considered testimonial? Testimonial statements are either written or spoken communications whose primary purpose is to establish or prove past events that are potentially relevant to later criminal prosecution. For example, affidavits or prior testimony. Question 5. What type of evidence is not considered testimonial? Evidence that is not considered testimonial includes observational evidence, so for example, lineups, as well as physical evidence, so urine or hair samples, as well as handwriting samples. Question 6. Is testimonial evidence found pursuant to a lawful search admissible? Yes. Question 7. Can the government compel production of testimonial documents, for example, journals? No. Question 8. How can a defendant invoke their Fifth Amendment right against self-incrimination? A defendant can invoke this right by refusing to take the stand. Question 9. How can a witness invoke their Fifth Amendment right? A witness can invoke this right by refusing to answer specific questions on the stand. Question 10. Can the prosecution bring a defendant's invocation of his Fifth Amendment right to the jury's attention? No, the prosecution cannot comment on a defendant's refusal to take the stand. However, adverse inferences are not prohibited in civil cases, but they are prohibited in criminal cases. These upcoming criminal procedure questions cover the right to counsel and identification procedures. All right, let's get started. Question 1. What are the 3 types of pretrial identification procedures? 1. Lineups, where a witness is asked to identify a suspect from multiple people. 2. You have something called show-ups, where a witness is presented with a single suspect. And then lastly, photo arrays. Question 2. When does a suspect have a right to counsel for a lineup or show-up? A suspect has a right to counsel at any post-charge, in-person lineup or show-up. Question 3. When does a suspect not have a right to counsel for an identification procedure? A suspect does not have a right to counsel at any pre-charge lineups or show-ups, as well as any non-live identification procedures. For example, examining photographic lineups, fingerprinting, or photo arrays. Question 4. If the police act in good faith, but the defendant's lawyer is absent due to his own negligence, can the police proceed with a lineup? No, this will still be considered a Sixth Amendment violation. Question 5. What is the remedy when a post-charge, in-person lineup occurs without counsel present? The identification will be inadmissible at trial, and the witness will be prohibited from making a subsequent in-court identification of the defendant unless the prosecution can prove that the witness has an independent source of identification.
And let's take a quick study break to remind you to drink plenty of water. Remember that your brain is so much better able to learn and retain knowledge when it's fully hydrated. So take a big sip and let's get ready for the next 5 questions.
Question 6. When do pre-trial identification procedures violate due process? Pre-trial identification procedures violate due process when the defendant can show that, in the light of the totality of the circumstances, the police intentionally made the identification unnecessarily suggestive and the identification produced an irreparable misidentification or is unreliable. Question 7. Due process applies to which types of identification procedures? All types of identification procedures at all stages of the process. Question 8. What are examples of impermissibly suggestive lineups? Examples of impermissibly suggestive lineups includes lineups where the suspect is a man and all of the other individuals are women, or a lineup where the suspect is one race and all of the other individuals are another race, or a lineup where the suspect has a radically different appearance than the other individuals, or lineups where the witness knows all of the individuals except the suspect. Question 9. When is a suggestive lineup not impermissibly suggestive? A suggestive lineup is not impermissibly suggestive if the lineup is justified by exigent circumstances. Question 10. What is the remedy for a due process violation during the identification process? The defendant can seek to suppress the identification via a suppression hearing. If the defendant meets his burden, the evidence will then be suppressed, and the witness will not be able to subsequently identify the defendant at trial. There is an exception to this, however. If the witness can identify the defendant based upon knowledge from a source that is independent of the impermissible identification, then they'll be allowed to identify the defendant at trial. These upcoming criminal procedure questions cover trial rights and procedures. All right, let's get started. Question 1. What is a grand jury? A grand jury is a group of people who act as an investigative body to determine whether there is sufficient probable cause to bring charges against a suspect. Grand juries are required for all criminal felonies that are charged by the federal government. Question 2. What is a grand jury indictment? A grand jury indictment is issued by the grand jury upon a finding of probable cause in light of all the evidence presented. This indictment formally charges the defendant with the crime. Question 3. Are witnesses entitled to Miranda warnings in a grand jury proceeding? No, because witnesses are not in custodial interrogation. This is true even if the witness is the defendant. Question 4. Are grand jury proceedings conducted in secret? Yes, grand jury proceedings are conducted in complete secrecy. There is no judge present, and only the prosecutor and the witnesses called by the grand jury are present. Question 5. Does the defendant have a right to present evidence or confront witnesses in a grand jury proceeding? No. Question 6. Is the prosecutor required to disclose exculpatory evidence in a grand jury proceeding? No. Question 7. What rights does a witness have in a grand jury proceeding? A witness has permission to leave the grand jury room and consult with their lawyer outside before answering a grand jury question. However, there is no right to counsel inside a grand jury room because the proceedings are closed and secret. Question 8. Does double jeopardy apply in grand jury proceedings? No. Failure for one grand jury to issue an indictment does not preclude another jury from issuing an indictment for the same crime later on. Question 9. Can a grand jury hear evidence that would be inadmissible at trial? Yes. A grand jury can hear evidence that would be inadmissible at trial, including hearsay or illegally obtained evidence. Question 10. What actions can a grand jury take pursuant to its investigatory powers? A grand jury can both subpoena witnesses as well as subpoena documents. These upcoming criminal procedure questions cover the Eighth Amendment, burdens, and appeals. All right, let's get started. Question 1. What is the Eighth Amendment? The Eighth Amendment prohibits the federal government from imposing cruel and unusual punishment, including torture or any punishment that is grossly disproportional to the offense. Question 2. Does the Eighth Amendment apply to the states? Yes. The Eighth Amendment was incorporated to the states via the 14th Amendment. Question 3. What qualifies as proportional under the Eighth Amendment? A sentence is proportional if the severity of the sentence is proportional to the crime. For example, 25 years for a $100 shoplifting charge would be disproportional. And the sentence must also be similar to the sentences of other similarly situated criminals who have committed the same or similar crimes. Question 4. Does applying a harsher sentence to a repeat offender violate the Eighth Amendment? No. The Supreme Court has held that imposing greater penalties for repeat offenders, for example, 3-strike laws, are constitutional. Question 5. Can a defendant be incarcerated solely for his inability to pay a fine? No, this would be unconstitutional. Question 6. What types of crimes are eligible for the death penalty? Crimes that result in a death or crimes against the state. Question 7. When is the death penalty unconstitutional? The death penalty is unconstitutional if the defendant was under 18 when the crime was committed, if the defendant lacks sufficient mental capacity to understand the imposition of the death sentence, or the crime was felony murder, and either the defendant was not a major participant, or the defendant was a major participant but did not act with a callous indifference to human life. Question 8. Is a mandatory death penalty for specific crimes constitutional? No. Mandatory death penalties are unconstitutional because they prevent the consideration of mitigating factors. Question 9. What is required for the death penalty to be constitutional? There are 5 elements. The death penalty statute must be clear and unambiguous. 2. The statute provides a procedure for review that ensures the death penalty is not arbitrary or discriminatory. 3. A jury is given an opportunity to review mitigating factors. 4. The jury had the opportunity to find the defendant guilty of a lesser included offense. And 5th, the jury finds evidence of at least one aggravating circumstance. Question 10. Is the death penalty unconstitutional if disproportionately used on one race? No, as long as there is no discriminatory intent. And that's the end of our criminal procedure study round.
To reach full mastery, remember to study in Brainscape. Our mobile and web app uses the latest in spaced repetition techniques, allowing you to optimize your study time and track your progress down to the finest detail. But of course, when you're driving, cooking, exercising, or otherwise unable to navigate the app, be sure to keep listening to the rest of this hands-free studying playlist. No matter what subject you're learning and what method you're studying it, Brainscape helps you rise to your challenge.